Folks, if you can come in and sit down and let us get started, because we've got a lot of ground to cover and not that much time to cover it, and like to leave some time at the back end for questions. The area we're on is a pretty hot topic at a lot of different levels, both at the local level and the national level. We're talking about wireless facilities and wireless siting. For those of you who don't know, I'm Tim Lay. I'm a partner at Spiegel & McDermott, and I'm serving a somewhat unusual role this year. I think this is my first time as a moderator as opposed to a speaker. I'm going to use this as my first tryout for maybe a second career as a late-night show host. So this will be a real rough start. This is not the tape I'll use for the job, but it's a warm-up act. Glad to have you all here, and we have a wonderful panel, and I'd like to get to it. And I think to save time, what I'll do is just sort of introduce all four of our speakers first, and then have each of them come up so I don't have to keep popping up and in between and introducing each one. And so I'll start down the line as we have it. Our first speaker will be Lorna Slott. She's Area Manager, Small Cell Business Development for AT&T's Antenna Solutions Group. And it's a good place to start because Lorna will be talking about, a lot of us have heard the phrase distributed antenna systems or DAS and small cell solutions. Those two words seem to go hand in hand all the time if you're at the FCC, and it's sort of useful to, I think, just have a tutorial about what type of services and what type of facilities we're talking about when we use that phraseology, DAS and small cell solutions. Next up, will be Lisa Veith. She's the Assistant City Attorney for the City of St. Paul, and she'll be talking to you about St. Paul's experience in working out an agreement. I believe it was with Verizon Wireless, if I'm correct, on siting wireless facilities and city light poles. And as an example of how cities deal with this, because what happens for a lot of cities, they are approached with the new technologies. And cities, of course, which are subject to various federal statutes, have to abide by certain requirements of those statutes. And you have to sort of think ahead of time. It's more chess than checkers, several moves ahead about what you're going to do, because there's the provider you have in front of you, but there will be more coming along behind who will probably want similar access. Next is Jonathan Kramer. Many of you, I'm sure, already know Jonathan. He wears several different hats. He's the head of the telecom law firm. Wonderful name, I always thought, Jonathan, for a law firm, for what you do. Although you don't get to, you have your name, Kramer and Associates and so forth. But since there's a lot of Kramers and fewer telecom law firms that actually have that proper name, maybe that's a better marketing tool. And finally is Jeffrey Steinberg from the FCC. Jeffrey's the Deputy Chief of the FCC Spectrum and Competition Policy Division. He's been at the FCC for a long time on a lot of wireless issues. You'd be hard-pressed to find anyone at the FCC more experienced in wireless issues than Jeffrey is. As a sidelight, I noticed that he clerked for then-Judge Stephen Breyer on the First Circuit. And of course, as you know, his former boss has since become a Supreme Court Justice. And with that, I will sort of bow out of my late night show audition and hand it over to Lorna.
Good afternoon, everyone. Okay, I was told that this was supposed to work better than the one in the other room, but it might be the user. So what I'm going to talk to you about today is a little bit about in-building services that are provided by AT&T. I'll give you the AT&T perspective. So as a part of my agendas, I'm going to talk about the drivers for in-building, the growing demand that there is for these services, as well as the in-building solutions that are available today. So this slide here pretty much tells it all, but I'll give you a little bit more details after this. AT&T wireless data traffic is increased 50,000% over the past 7 years. I mean, that's unprecedented growth. We have over 100 million US wireless subscribers. So there's a lot of demand for our network. In this slide, you can see that this is the number of smart devices that are in our network today, as well as how it's grown over the past. You can see the growth is that we now have 77% of our subscribers now have smart devices. And then some of you may have seen this stat before, is that 80% of the worldwide data connections initiate in building. And that is so much the reason why AT&T is focused on building our network from the inside out, as opposed to in years past, where we were always concerned about making sure that we were building capacity and access along the roadways where people were using their cell phone devices with voice. So what AT&T is doing about this is AT&T formed a team called the Antenna Solutions Group about 4 years ago. There's approximately 500 people plus in the organization. What we're focused on is building our system out, and we focus more so on places where we have a lot of traffic, like stadiums, convention centers, airports, hotels, et cetera, et cetera. So how do we do this? There's a couple of things that we have in our tool bag to help us increase capacity as well as provide additional coverage. And the first way is through neutral host distributed antenna systems, or DAS systems. We also are now in the small cell space, and I'll talk a little bit more about that technology. It's very new. We actually, it has been kind of an ambiguous term, and it's all-encompassing, and AT&T actually has some products that we are deploying into our network, or a product today that we're deploying into our network that is what we call a small cell. And then we'll talk about Wi-Fi and how that plays into the capacity need in our network. So some of you might be very familiar with DAS technology. It's been around for a number of years. It does add capacity into our network for those high capacity demand facilities. These are multi-carrier systems for the most part. The economics are much better when we build a multi-carrier system because we can share that system with other carriers. Therefore, we're not taking on the burden of the entire cost. These systems are very expensive, so it limits us in terms of the amount of DAS systems that we can put into the network because of the expense. Okay, small cells. These devices can be used indoor or outdoor. Today we're deploying Alcatel-Lucent devices, and the devices that I'm speaking to here, they cover about 7,000 to 10,000 square feet. You can have up to 32 simultaneous users connecting to the device. And today they're 3G, but in the very near future, in 2015, we expect to have an LTE version of this product. There are also other manufacturers that are coming in that are creating these devices for future deployment. So a little bit more about the small cells is it really does help us to offload our network in those areas that we wouldn't put a DAS, but we cannot reach with our network. Sometimes it's very difficult to cover a building from the outside in with our macro network. So the small cells are very nice for us to be able to use to cover those small pockets where we need coverage, but it's just kind of impossible to get it from the outside, and DAS is not a good solution. The future devices that will be coming out will also have Wi-Fi capabilities as well. And you can see here, if you look, and show you a little bit more about this. If you see the device here in this picture, that's actually what the device looks like. And you can see that it's got the little rabbit ears there, that's the antennas. But in this picture here, you can see that off of the antennas, what we did is we actually wired antennas so that we can put those underneath the ceiling and we can lay the other device on top of the ceiling. So it helps out with aesthetics where we need to have the devices be hidden. As I stated, Wi-Fi is another area that we're using to offload our network. These are easily deployed along with the small cells. Wi-Fi is a technology that's been well adopted, and it's really definitely a technology that we continue to use in the network to make sure that we can continue to provide a good end user experience. Okay, so just summing this up, this is just a comparison of the different types of equipment that we have in our network. So we have the macro BTS, which actually use for our cell sites, as well as we have BTS systems that are a little bit smaller that we use to drive our DAS systems. We have the distributed antenna system, the DAS systems that we put into larger venues. And then the repeaters are bidirectional antennas. That's some technology that has been around for a long time. The issues with those is that they're great for providing coverage, but the issues that we see with those is they do not provide additional capacity into our network. And as you could see by the slides in the beginning of the presentation, we absolutely need to drive capacity into our network. So we're moving away from that technology. And then the small cells, which I spoke about today, and this is really the direction of the industry is to provide more product in this space of small cells, something that's a little less expensive to deploy, easy to deploy, covers those areas that DAS is just not suitable for. And then the last one here is the femto cells, and those are available today. You can actually purchase them in our stores. I think all the carriers provide those, where they're at-home devices, or you can actually use them in a small office. They provide coverage and capacity for a small number of users. So that's what I have.
I'm Lisa Veith. I'm an assistant city attorney for the city of St. Paul, so I'm the Lake Wobegon member of the panel here. It's a great pleasure to have you in St. Paul. I was at my very first NATOA conference and probably didn't even know at the time what an LFA was, and kind of got sidetracked when 9/11 happened. But I appreciated being with all the NATOA folks at that time. You know, if you couldn't be at home, at least that was satisfactory. And so it's good to be back here with all of you. In the state of Minnesota, municipalities are not permitted to franchise telephone services, which is very common. But we have a state statute, which is Chapter 237 of Minnesota State Statute, that permits cities to regulate uses of their rights-of-way, and they can choose to do so via city ordinance. And St. Paul enacted the right-of-way ordinances in 1996, but even after 18 years, they've proven to be very robust and effective in monitoring all kinds of uses in the right-of-way. And I like the preamble to our ordinance because it reorients you to what the role of a government should be. The City Council enacted this, which says, "The city recognizes that it holds the rights-of-way within its geographical boundaries as an asset in trust for its citizens. The city and other public entities have invested millions of dollars in public funds to build and maintain the right-of-way. It also recognizes that some persons, by placing their equipment or facilities in the right-of-way and charging the citizens of the city for goods and services delivered thereby, are using this property held for the public good. Although such services are often necessary or convenient for the citizens, such persons receive revenue and or profit through their use of public property." And then it goes on to enact the requirements for right-of-way users to register with the Public Works Department. Last year, the Public Works Department here in St. Paul was presented with a request from Verizon to place some small cell equipment on its light poles and some traffic signals in the downtown area. I'm also the attorney for the city's Board of Water Commissioners, so I've had a number of years of experience negotiating water tower leases, which are, apparently they've been a totally hot piece of real estate for quite a few years. And the water tower leases have one really helpful characteristic when it comes to negotiating leases, which is their primary purpose is to supply water. So once you have that as your starting point, you can pretty much negotiate and say, we're in charge here, you know, our use trumps all other uses. But with the light poles and the traffic signals here, I found it second nature, I think, among city people in particular to raise questions with their city attorney about what if everyone starts demanding space on these same poles. And, you know, it's an interesting question, but my approach to this has always been, you know, don't get too caught up in that because you'll just be spinning your wheels. You know, and despite being a lawyer, I'm a person of some common sense. And water tower leases, you know, have been operating very well for many years on the very scientific principle of first come, first served. And now the water towers are pretty big, so you know, you don't have too much problem with getting overcrowded, but light poles, you know, can only hold so much cell tower equipment before they become a safety hazard. And interference with traffic signals is probably not a good thing. So, you know, I have just operated under the principle that no carrier is going to insist that its equipment be placed on a pole that might be at risk of crashing down. And now in the negotiations with Verizon, these went very well. They were very amicable. We didn't really have it, you know, we did a little bit of back and forth, but it went very well. And what we did was we worked out a master license agreement with Verizon, which lays out all the terms and conditions, you know, for their overall project. They were proposing, I believe, 20 sites. And each particular site then is covered by a supplement. And I've made the master license agreement available in the NATOA materials, and it has a sample supplement attached. And it ensures that any pole upon which Verizon's equipment is placed is tested and determined to be capable of withstanding the weight of the equipment. And if it is not, Verizon will replace it with a brand new light pole or traffic signal. I'm not sure how many traffic signals they'll be doing, but I think it's mostly light poles. And those automatically come under city ownership. And I'll emphasize that Verizon offered those terms right up front, which was very much appreciated. You know, they seem to be prepared to address our concerns, you know, which, for example, would be, well, what if they put in a light pole and now they own the light pole? Well, you know, how do you deal with that if they take their equipment off it, et cetera? We had it worked out so that it was pretty slick. And Zayo is their selected fiber provider, which under our right-of-way ordinance only needs to go through the right-of-way permitting process. And I'll give you a little bit of the city right-of-way ordinance, you know, just to give you a flavor of it, but it's, there's a section 116, or chapter 116, excuse me, that talks about right-of-way in general, and then the permitting process, for some reason, is in chapter 135. I don't know why. But it provides that anyone who wants to put stuff, and like I said, this ordinance has proven to be very robust because it, you know, even though many of the types of things that people want to put in the right-of-way didn't even exist at the time it was written, it's still broad enough to cover them. So they register with the department, and There's also a utility coordination committee. The city actually has a committee that meets every week and has to coordinate the placement of, all the stuff that goes, underground and above ground. And they really do have to keep track of it. I got an update from my client just yesterday. He confirmed that 8 supplements have been submitted by Verizon, and they're set to be reviewed next week. And I believe that the small cells are supposed to be in operation by the end of the year in the downtown area. Now, there's also, the ordinance does address the limits on space that I was talking about earlier, which says that the director, which is the director of public works, shall have the power to prohibit or limit the placement of new or additional facilities at specific locations within the right-of-way if there's insufficient space to accommodate all the requests of registrants or persons to occupy and use the right-of-way. And it goes on to say that the director shall strive to the extent possible to accommodate everyone, back to common sense. But one issue that I think is probably pretty common in any of these negotiations is the rush factor. And it's, you probably are all familiar with this too, but it's the story of my life that, any project was supposed to start, yesterday or last month. But that's, obviously not going to happen, and I'll just give you a quick rundown of some things that are always going to take time. It's never going to go quickly. The first one I have is circling, which is that a carrier can start by going to the mayor's office, or they can start by going to the city engineers. But either way, they're going to have to circle back to each other because neither one of them has the authority or the expertise to say, yeah, go right ahead and do this brand new thing that we don't know anything about. And, the city attorney is always the one who gets called on, and as if I know anything about technology, but that's still my job, and I need to be brought up to speed too. A presentation like this is very helpful, and Verizon did give us a packet that explained what small cells were, which was my introduction to what they are. It's a new technology, and as usual, technology is outpacing the law. Another item is checking of radio frequencies and possible interference. That seems to be something that both sides say, well, are you going to check it? Well, are you going to check it? So it's good to do some advanced testing, and because water towers and traffic signals going down are going to wreak a lot more havoc than any bad server connection, just saying. And you've got the aesthetics and historic districts. Those are the things that generally get brought up for litigation. And, St. Paul has a lot invested in its historic reputation and preservation, as I'm sure you've all noticed, in our lovely city. But there is, and in most historic cities, there's a great deal of political pressure to preserve it. And so it's really not possible to just rush these kinds of things through because you're going to hear about it from whoever's observing. And then I have to keep my promise to Jonathan Kramer, which was, I said the theme of my speech was peace, love, and cooperation. So, the last thing I want to point out is that these kinds of agreements can go very well if both sides cooperate and use some common sense. I would encourage companies to expect that cities want them to take care of any transfers and assignments because we're not staffed to follow every technology transfer of ownership, obviously. And from the public safety side, I've had to redline some proposals that have been given to me in the past. Just crossing out the things that, that say that that the company can go on work with our public infrastructure without any express approval. That just doesn't work with cities. The citizens expect us to know who's out there and what's going on and that it's safe. And in closing, I'll just say that, you know, it's my experience that cities really do their best to try and juggle all of these interests. They're dealing with a lot of things, and you get complaints that you never would have foreseen at just about every turn. So I don't see any cities trying to be an obstacle to broadband deployment or any other kind of wireless deployment. You know, the obstacles are already there, you know, and we just have to deal with them. So again, it's wonderful to have you here in St. Paul, and feel free to ask me any questions. Thanks.
Wireless is good. Their customers are our constituents. That should be the way that we approach this. From that, then we go down to the actual nuts and bolts. And I'm an engineer as well as an attorney, so I'm going to try and address some of that during my lecture today. Silly. You don't know, you don't care about that. Before I talk about really probably the most important subject, I just want to spend a couple of minutes talking about RF safety, because for those of you who have contentious wireless hearings, they tend to be on a subject one of two things. Number one, RF safety. Number two, property values, which are often a shill for RF safety. So let me just talk about one thing that's happening at the FCC, which is that the Commission is hopefully near a decision on, I'm looking over at Jeff because he's the FCC, and so I'm gonna kind of lay some groundwork or landmines, I'm not sure which, for him. But the Commission is going through a process right now to update its RF safety standards. The RF safety standards have always been kind of an amorphous blob to most people. I have to keep an eye on time because I have a lot of slides to get through, but I will simply share with you some slides that I use to explain the current RF safety standards. If you start with a ruler, and if you know that at the top of the ruler, that's the point where you can actually measure some physiological change, in this case heat, from RF. Anyone know where the FCC standard is on this 12-inch ruler? Anyone want to guess? Surprisingly, it is down there at about 1/4 of an inch. There's a 50 times safety margin. Oops. There's a 50 times safety margin built into the current FCC rules, and probably will be built into the next set of rules as well. So we've got some really good standards in place. That said, we should expect, hopefully, to hear from the Commission about updating its standards fairly soon. That'll be important for you practitioners out there to make sure that your cities and planning commissions and so forth are updated about that. In that regard, are the safety standards adequate? I think 50 times safety margin probably is. And you'll often hear from the public, well, the government lied to us about cigarette smoking, but at least in this case, there's really good science and transparent science behind how the FCC came up with its standards. 14 years ago, that guy down there and I had the final hands-on the LSGAC guide, and it's a document that has stood the test of time in terms of providing good information to the government and the public. An update on that, which is that last year the IAC asked me to revise that and bring it into current, well, frankly, to translate it a little bit closer into English. So as a heads up, our draft of that new guide will go to the IAC in November, and it will go through some last-minute adjustments once the Commission releases its new RF safety standards. So a heads up on that. So here's the really big news, which is for all of us, the rules in terms of understanding what 6409, Section 6409 of the Middle Class Tax Relief Act means. The rules consisted of 149 words. Yeah, those. And they don't tell us a lot, so the Commission took 86 pages in the Notice of Proposed Rulemaking to talk to us about that and what they think it means, and the industry has talked a lot about that as well. This is what it modifies. 6409 modifies the Telecom Act and local authority. And unfortunately, what it ends up doing, we're not quite sure. We'll hear from the commission, oddly enough, 2 weeks from this Friday, when the commission votes to adopt the report and order. And hopefully it'll come out probably, what, 5 days later, 4 days later, something. Good answer. So at some point fairly soon, we're going to know what the commission thinks about 6409, and those will be the rules, and we'll go through the process. Inevitably, there'll be petitions for reconsideration. They'll be denied, and then we'll just get it. What? I'm just giving you an opinion. And here's some of the interesting things that we'll be talking about, or we'll be looking for in terms of the report and order, in terms of the commission. You've heard a little bit already about small cells. Lorna's talked about that. Lisa's touched on that in terms of Verizon. I'll talk a little bit more about it. The PCIA's proposal is that a small cell should be 17 cubic feet, and then an unlimited number of 3 cubic foot antennas. Let me show you 17 cubic feet. Just to give you an idea of what we're talking about. Another aspect of 6409, which we hope the commission will clarify, is what is a substantial change? Is a substantial change going from that to that? Under the plain reading of the law, it certainly could. We're hoping the commission will clarify a lot for us in terms of not losing camouflage, whether it's continuous growth, things like that. These are all huge issues in terms of planning and local authority over zoning. This is what we're turning into now with all sorts of additions about the 4G and adding remote radio units. It speaks to the issue of what is camouflage and what is preservation of camouflage. At the same time, the commission is talking about revisiting the shot clock. We know now that the Supreme Court has upheld Chevron deference in this area for the commission, so one of the issues right now is whether the commission will adopt an industry proposal that would make co-locations a 45-day proposition. And secondly, if the local government misses that very long window, that the project be deemed approved. Those are critical issues because, frankly, if that's the case, my suspicion is we're going to see a lot more denials simply because we can't meet the timeline, but we'll see. One of the industry proposals by Verizon is asking the commission to adopt a stance that if any facility can support a wireless antenna, it is a wireless tower, and therefore every new site on an existing structure would be subject to 6409. Remember those famous words, quote, may not deny, comma, and shall approve, unquote. And then if it's a co-location under 6409, then it must be subject to the 45-day shot clock. So everything could change. And these are the questions that we're looking for the commission to answer, and then most likely the courts. Some real small cells. You know, this is nice. I will be done. I will be done. I'm getting to the end. Just calm down. Lorna showed you some pictures of small cells. Let me show you some of them in situ. It's a legal term. Forget about it. So what do you is this horrible? Of course not. Isn't this what you just saw in her pictures? These are actually deployed already. Where? London, England. These are small cells, there's no question about it. And I expect a lot of ordinances to change to reflect this to make the path easier. And I'll close off. I will close off now with some really nice cells. Hang on. As a wireless site, it's a pretty cool one. It's a very nicely designed one. Let me show you some more from that same community. They even have faux dates for the faux palms. And in another one I found in the same community, the design is so good, those are live storks that have built nests into the monopalm. Where is this? Marrakesh, Morocco. Why can't we do this good stuff here? But here's something that's actually here. Now wait. This is an outstanding cell site, and I'll tell you why. It's in Carr, Colorado. It's a mile south of the Wyoming border. It's on an otherwise naked hillside, and Verizon took a site and made it public art. And go look at it at my website. You'll see in how it really looks. This is really an outstanding design. And frankly, it just goes to show you how creative the industry can be to solve problems. And I actually respect for that. Verizon site. The barn is real. It was there. Verizon built the silo. Come on, is this terrible? No. And finally, a mono lighthouse, obviously a faux lighthouse in Dana Point, California. The references here you'll be able to download from the NATOA site when you get your copies, just some references and things to look at. And thank you. Thank you.
So, was I supposed to talk about the infrastructure rulemaking? Yes, I am. Says so right there, so I can't really fake it. Afraid I'm not going to have much to say, Jonathan, about the RF rulemaking, in part because it's another part of the commission, so I don't even really know what's going on there. But I mean, I am familiar with the proceeding. I am going to run through these first couple of slides pretty quickly, in part because Lorna covered some of it, but I did want to just talk a little bit from the FCC's perspective about the benefits of DAS and small cells. They are critical to meet the rapidly growing demand for more bandwidth. I put a couple of statistics of my own up there. The first one's from Cisco, that mobile data volumes expected to grow almost 11-fold from 2013 to 2018. And another one, this is the National Center of Health Services, that more than 41% of U.S. homes are now wireless only. So what the DAS and the small cells will do by far as way of benefits is that they fill indoor and outdoor capacity and coverage gaps. The indoor and the outdoor you're familiar with, capacity and coverage. In some instances, particularly some indoor spaces, they may, fill in where there simply isn't coverage. But what it's a lot more of is places where there's some coverage, but because of the increasing volume, it just can't accommodate all of the data uses, and at some point it becomes impractical or obtrusive to keep building more traditional type cells. So these services will enable to accommodate the new capacity needs. They can enable sharing of infrastructure. That's DAS in particular, not the small cells so much. But more and more you're seeing DAS systems come on that are neutral host, where somebody is providing it, and multiple companies can actually use the same set of antennas and connecting equipment, and it's partitioned off in ways that are completely magic to a non-engineer like me. But they do enable the sharing in that sense. And another side benefit of that from a public safety standpoint is that your public safety systems can share them too. They clearly have, in general, less environmental and aesthetic impact than the big sites that you're used to. And in part for those reasons, I've conflated a couple of different analyst estimates here, but one analyst who said 37 million small cells in the US by 2017. I've seen another report, 16 million DAS nodes by 2018. So, these are really ongoing wave. Just quickly, and I'm sure you've seen a bunch of these sort of things, but these are a couple of installations. These happen to be in Georgia. Okay, before I move on to the rulemaking, let's move on. There we go. I just want to go, just a very high-level overview. What are the FCC's goals with respect to DAS and small cells? There. One is to, the overarching thing is to promote the deployment of these beneficial services. This is the FCC's core mission, Section 1 of the Communications Act. Sort of going hand in hand with that is encouraging the innovation that can be made possible by having all this bandwidth available. 5 years ago, you wouldn't have imagined all the things that are available today. I'm sure there will be things 3 or 5 years from now that we can't imagine. Promoting infrastructure sharing with both the environmental and the competitive benefits that can enable, advancing national security and public safety. So to serve all those things, we have the goal of eliminating unnecessary regulatory impediments. At the same time, it is important to our goals to preserve environmental, historic preservation, and local land use values. And we think that what we can do is achieve those at the same time as we are achieving all of the deployment and related goals. And finally, comply with statutory mandates that, of course, underlies everything that we have to do as an agency of law, and that would include both mandates under the Communications Act as well as mandates under other statutes that we are subject to. So, quickly going over, the overview of this rulemaking, for which the notice of proposed rulemaking was issued last September, just a few days before the government shutdown. There are 4 parts to it, which I'm going to talk at least briefly about 3 of them. One is the FCC's own review of DAS and small cells under NEPA and the National Historic Preservation Act. Second one, which I'm not going to spend any time on, is an exemption from our environmental notice process that would apply to certain temporary towers for which the environmental process, the notice A would serve very little purpose, and B is impractical given that these are often needed right away. It's actually a fairly small set that's subject to it anyway, and this would be codifying a waiver that we've already had in effect for some time now. Then the third one is the implementation of 6409A, and the fourth is clarification of 332C7 and the shot clock. So just fairly quickly, since it's probably not this audience's primary interest, but I do want to talk a little bit about the NEPA and NHPA review of the DAS and small cells, which is a matter of reforming the FCC's own rules and processes. Under current rules, many of these are excluded from review under one or the other of these statutes, but our current exclusions were not written for DAS and small cells. They were written for the larger sites. So as examples of some kind of things that may not be quite right in the current rules, under the NHPA, while many co-locations are excluded, if it's a co-location on any structure that's over 45 years old, including a utility pole that's over 45 years old, it then becomes subject to our review. Under NEPA, any new construction that's not a co-location requires review, even if it's putting a new pole up in a right-of-way that looks just the same as the utility poles that are already in that right-of-way. So what we did in the notice was we sought comment on whether to put in place further exclusions and other process efficiencies. What the Commission is looking to do in the upcoming report and order is to clarify the application of our existing exclusions, which just were not written for the current world. For instance, it just talks about co-locations on buildings and towers. It doesn't talk about any other structures. And also to put in place some further exclusions where there is no possibility of an effect. We have a longer-term goal to put more efficiencies, including potentially more exclusions, but that requires more consultation and other processes. The only other thing I want to emphasize about this is whatever the FCC does in this area does not affect state and local authority to implement your own processes. It's purely FCC fulfilling our own obligations under federal statutes. Okay, Section 6409A, I reproduced some of the same text that Jonathan posted in his slides, a little bit more briefly, pulling out, more the key provisions of it. But I won't bother repeating that. So what are our goals specifically with respect to implementing 6409A? So this is focusing in more on the rulemaking. One thing that we think is important to try to do is simply clarify the definitions. As Jonathan said, 149 words. very broad-based. There are a lot of terms that it's just not obvious what they mean, that they're not defined anywhere, and we think that would just in itself help reduce disputes, avoid litigation, and help the process go more smoothly. The goal to facilitate timely deployment of co-locations that will not implicate local land use values. That's fundamentally, we think, what Section 6409A was intended by Congress to do. At the same time, it is important that we preserve local government's ability to ensure public safety, things such as building codes, and to ensure that you're able to maintain consistency with defined land use criteria. We also think it's important that local governments have the ability to ensure that if somebody claims that an application is covered by this statutory provision, that it is in fact covered. We want to ensure efficient dispute resolution, and there's a lot of room for debate about exactly what that means, but it's important that, from all perspectives. And finally, we do want to faithfully implement congressional intent. That means both the congressional intent to facilitate co-locations, as well as clearly it must have been an intent in there not to override, basic and important local government functions. So it's a balance of those two. So what are the issues that we're going to address under Section 6409A that were teed up in the notice? There are several of them. One of them is the definition of transmission equipment. Which, is it, just the antennas? How much broader than the antennas is it? As well as what kind of services are wireless within the meaning of this provision. Definition of existing wireless tower or base station, and Jonathan alluded to some of that. That's a term, those words, and you can parse that out further. What is a tower? What is a base station? What is existing? They all need to interact, and we received some very interesting comments from a perspective, a wide variety of views on those things. What are the types of co-locations and modifications that are covered by the statute? What does it mean to substantially change the physical dimensions of the existing structure? We proposed in the notice as a possible starting point a definition that we apply in the historic preservation context, but there is a lot to consider there, including some of the local governments have suggested that a lot may depend on context. So there are. Again, there's a lot of balancing to be done there, and those are important issues that are going to be addressed. What are permissible processes that local governments can follow? That does the statute limit what processes can be used? If so, in what way, so that local governments reasonable authority is preserved, but at the same time there are not unnecessary procedures imposed, which we think Congress did not intend, and what are time frames? It says must approved, shall approve, may not deny. It probably doesn't mean shall approve 3 years from now. But what exactly does that mean? What remedies are there if there's a dispute over whether the local government acted properly, or if the local government did not act properly, what can be done about it? And finally, the one other question was, does this apply to a local government acting in its proprietary capacity or only in its capacity as regulator, and what exactly does that mean? Fairly quickly, the last piece of this is some targeted possible clarifications or on the shot clock on order from Section 332C7, where the Commission only asked a few targeted questions, and we're looking to possibly clarify that. One is in the whole area of completeness of applications. The current regime that we have, the declaratory ruling, does provide for tolling of the time period if an application is incomplete, but there may be benefit to clarifying exactly how that process operates. So that's one of the things that the FCC asked about and is likely to act on in the upcoming order. What is the applicability where there is a local moratorium? How do those things mesh? What's the applicability of the 332C7 to DAS and small cells? What is the definition, since we have the different time periods in place for new builds and for co-locations, and we did provide some guidance in the earlier order, but are looking just on whether there should be further guidance given on when does something become a co-location, if it's a potentially some kind of more than just slapping an antenna up. This was an issue raised by some of the industry. Does 332C7, is it violated by preferences for using municipal property? And finally, some similar remedy questions to what we've been asking under 6409A. Timing next steps. As we've said, it's been mentioned several times, the item is on the tentative agenda for the October 17th Commission meeting. That doesn't mean for sure that it will be on the final agenda, but at this point, I think that would be an appropriate working assumption that it will stay there. If it does remain on the agenda, that means meetings with commissioners and commission staff will be permitted through October 10th, at which point we enter what's called the sunshine period, where such presentations are forbidden in order to maintain transparency, give the the commission a little time to be able to retreat a bit and actually make its decisions without potential last-minute influences. And the rules likely to be released shortly after the commission meeting. We strive to release the order and the rules the same day. Sometimes we make that, sometimes we don't. But I would think that in all likelihood it would be most likely within the week. There are times when, for whatever reasons, we are not able to make that, so that's not a guarantee or a promise in any way, but if you're forming some expectations, I think that would be a reasonable thing to assume may likely happen. Okay.
And yes, Jonathan, now I have the clock on me and all the rest of us, so, I will do that, and I'll have to be both good Tim and the cable subscriber, bad Tim, up here at the same time on this. And with that, people who have questions, feel free to, I think we got a mic for that purpose there to line up. And while we're starting, I had a couple of questions that I might throw out to the panel. And one of them related to something I think Jeffrey and Jonathan both spoke to, and that is one that Jeffrey spoke to was the National Historic Preservation Act review and the NEPA review, Environmental Policy Act review, and he correctly noted that in one sense those provisions do not affect local authority. In other words, even if the FCC categorically exempts a certain type of co-location or facility from its National Historic Preservation Review or its NEPA review, that in no way preempts state or local authority review over that facility. But where the bridge happens, and I wanted to raise it with the panel, is under 6409, there have been a lot of arguments about incorporating in the national co-location agreements, various agreements that do in fact relate to the Historic Preservation Act. And of course, the difference is that if you have a categorical exclusion and you use the same definition to apply what preempts in 6409, the result is, I'm being good Tim right now, I'm not being bad Tim yet, to Tim. Then you are talking, then the linkage between the two is, if you borrow the definition, you do end up with total preemption for anything that falls within that category. But I throw that out to the panel for anyone to discuss.
Is that on? Yes. Yes, that's an accurate observation. Mm-hmm. I think that to the extent that the commission does that, it would be based upon our judgment that, for the same reasons in this instance that, that a certain co-location is appropriately exempted from NHPA review, that, that it also satisfies what Congress had in mind in Section 6409A, but it would be, it would be a judgment based on the two sources of law independently.
Anything to say, Jonathan?
Yeah, more questions are better than my answers.
Okay, Jer.
Actually, I had a question for Lisa, if I could. Lisa, you talked about in some of the new infrastructure deployments, testing. You said something about that there should be testing on whether or not these new deployments meet weight standards and whether or not they meet RF standards. I guess what I'm intrigued. It sounded to me like you thought that the city would participate in that testing as opposed to simply putting the requirement on the carrier. Did I hear you wrong? I mean, are you simply putting the requirement on the carrier, or is the city actually participating in the testing?
No, the city would participate in reviewing whether or not the equipment meets the standards. We have a lot of engineers on staff who, they've been telling me that they have several of these supplemental agreements in front of them right now, and they're looking them over carefully to make sure that they find them to be safe. I'm not quite sure how much they're interacting with Verizon because, this just started, so, and we don't even have one up yet. But I do know that the city wants to, have a say in how safe the equipment is.
And Jeff, if I could just ask one question. I won't ask about the story in telecommunications report that says that we should expect deemed granted to be in the order, but I was wondering, did you give us a little bit of an insight when you said one of your bullets was to ensure that the applications are in fact eligible? I think one of the biggest issues for local government was in fact that for these 6409 applications that there would in fact be an application that somebody would have to review. Are you able to tell us whether or not that's an actual element of the order?
I mean, I can't speak for sure to what the commission will vote on. We're still, in the process where, other than the chairman, the commissioners just got a draft order last Friday. So, I mean, anything can happen in the next few weeks, but I think that the likelihood is that, that there will be a process in place by which, that the local governments can ensure that yes, that that something will be submitted so that there can be some form of review to ensure that you're not just taking the the company's word that this is something that's covered and they just go slap it up without telling anybody.
And anything on the stealth issue or the camouflage issue that Jonathan raised?
I mean, those are very definitely being considered. They were raised in the context, among other things, of what is considered substantially changing the physical dimensions, and the commission is giving those issues very serious consideration in that context.
Next, if you could state your name, please.
Hi, I'm Debbie from Hawaii. I work in the cable television and broadband department or section. The question I have, I guess, I'm familiar with joint pole and things like that because I worked at the utility for most of my prior career. But the question I had was that in Hawaii, I noticed that there's a lot of broadband, Wi-Fi hotspots coming up on the lines, on the poles, and actually on the lines themselves. And it's very similar in shape and size to these. Is there any regulation on that is applicable to this as well?
Let me take a crack at that. You're talking about Time Warner Oceana Cable. They're deploying Wi-Fi hotspots, as is Comcast, Bright House, and a number of others. This is an issue which is often a state regulatory issue because what they're providing is not a cable service per se, they're providing something else. It's very confusing. In California, it's not specifically authorized under our State Franchise Act, this is a issue or state-by-state issue. And in California, a lot of the jurisdictions are requiring that those facilities be permitted as wireless facilities because it falls out of the regulation, it falls out of the authority of a cable system. There's some sense to that, but I think that these things will be clarified over the next couple of years as more Wi-Fi facilities are deployed. As a practical matter, I'm still holding that the cable industry is going to be providing a tremendous amount of backhaul because look where they are. They're already built in the backyards and the front yards of really the holy grail area, which is residences. So we're going to see a lot more, and these things will ring out.
Okay, thank you.
I don't know, well, if we don't see, good, another question will save me from thinking up one.
Question and basically a comment that I'd like to get some comments from that I make. George Brown, City of Jackson, Mississippi. I've been attending small cell presentations for almost a year now when the plan first came out for small cell. Being a municipality, and we have to make sure that we control the status of our rights of way and the future build-out plans that exist. We hear the mention of so many small cells projected to be built within the next, let's say, the near future. And I don't think anybody has really looked at it from a holistic standpoint to realize what all of these particular small cell build-out would mean to a municipality. I've had a presentation from Verizon, and they were the first provider to come to us to present their plan. And basically, they said, we're just going to be truthful with you. What we really need to do is to deploy small cell at least every 400 to 500 feet on poles within your city. So they were truthful. Now you look at Verizon, and basically all of these are proprietary. Then you look at AT&T wanting to do the same thing. You look at Sprint wanting to do the same thing. And once everybody does that build out, you have small cell on every utility pole within your city. Now, as Jonathan mentioned, the size of these cabinets that being mounted on the poles are projected to be mounted on the poles, and that's just for starters. Just as cell towers, the antennas have gotten larger, the RRUs have gotten larger, and you have to do modifications on your tower structure to be able to accommodate all this extra size and all this extra weight. And then I envision that you're going to be looking at the same thing on small cell, because once the demand increases, so increase the demand for your infrastructure of the radio units that's mounted on these poles. So you're looking at a big mess on all of on all of the utility poles that's inside your city. I'd like to comment on that.
One of the issues you have to consider in a situation like that, and I agree with him, I think that we're going to have a tremendous number of small cells picketing pole to pole to pole. That's not necessarily bad if the deployment is rational, the designs are small, they're done like in London where they're painted to match the underlying poles, things like that. Really, one of the interesting impacts is going to be the impact on the roadways. Because in areas where there aren't overhead lines now, it's going to require new trenching. So coherent plans about how that's done so that you're not having the same roads dug up 4 or 5 times for additional scarring purposes for new fiber, that's going to be critical. So a lot of coordination is going to be necessary to make sure that there's a rational deployment that doesn't really damage the roadway, which has always been a tremendous concern for local governments.
Yeah, and I'd add to that, I mean, there are a couple of issues, and one of them is very big in 6409. I don't necessarily ask the panelists for their comments on it. And that has to do with, I mean, it's interesting because 6409 itself, ostensibly, there's virtually no legislative history on it. It was added to, at the last minute to a much, much larger bill.
And it was wrong.
Well, and ironically, when you read it the first time, it appears to be a move by the traditional wireless industry addressed at one of the large concerns of the wireless industry at the time was what I call the grandfather permitted use problem in a lot of jurisdictions where you had an existing tower, but it was in an area that had since been rezoned. And under a lot of local zoning ordinances, although that tower has a right to stay, any modification to it thereafterwards must get approval, and that was a thorn in the side of the wireless industry, understandably. But then in the rulemaking proceeding, in the comments, obviously for deployment reasons, small cell and DAS became a very big issue. And then the tug of war became, well, how can we apply 6409 to small cells and DAS? Now, when you read 6409 just the first time, because actually the DAS providers are very honest, and they're saying what we really need access to are utility poles and light poles in the street. Well, you don't really think of a utility pole or a light pole as being an existing wireless tower, but that becomes sort of the big tug of war because the proceeding, the emphasis has sort of switched more toward promoting DAS and small cell deployment. The other issue, and this is just the cynic side of me saying, it's not cynic, but it's just looking at it from a little bit of a different view, that is, the wireless industry is known for some time, and there's been huge wireless deployment in this country since '96, and it's accelerated ever since, notwithstanding these supposedly incredible obstacles placed by local zoning on it, according to what industry says. But they know that there's going to have to be huge additional deployment. So my own view, the cynic's view, is behind 6409 is industry knows it's coming, so let's get a law passed that knocks locals out of that box before it comes, so they won't have any say-so over it. Now, that, granted, that's just a one-sided opinionated view, but it is interesting how the proceeding, the emphasis has sort of shifted towards small cells and DAS, even though if you look at 6409 itself, that isn't really what it, on its face, appears to be directed at, because most small cell deployments are not interested in being deployed on a traditional large cellular tower.
And would Lisa allow the small cell Verizon deployment to happen if it turned out that 6409 made that a co-location eligible site outside of the
Would turn it into an existing tower, which would then trigger the right of everyone else to go on, and you would have no denial approval over it whatsoever.
Well, I can't predict how people will react to it. That's kind of what I was getting at earlier, is that a lot of questions come up then, well, what about the next one, and then the next one, and then the next one? And, you know, I mean, I just have, you know, on principle, I do have a problem with the requirement that you must allow this, because I think that, you know, people are interested in better broadband coverage, but, you know, if a particular community is willing to wait for, you know, a new technology that's smaller, you know, I mean, they seem to be getting smaller and smaller. You know, one of these days, you know, this pen cap might be a small cell. You know, I think that they should have, you know, the prerogative to do that. And right now the law does seem to permit communities to say, no, we don't want that, and here are our reasons. But it seems to be tilted in favor of the industry, where they have, you know, the opportunity to litigate anytime a community says, no, thank you, we don't want it. I'm not sure why that's such a terrible thing. I know that we want, you know, broadband deployed, but you know, at what cost? And, you know, and if people say they don't want it, or they want to wait, they should be able to do that.
Well, and it's one of the peculiar things about 6409, and it's what happens when legislation gets drafted at the last minute, is it's very peculiarly worded, and I don't envy the FCC's problem in grappling with it, not just the obvious definitions, but it's sort of weirdly written in the sense of it says a locality may not deny, and then, in case there's any doubt, and shall approve, which I sort of think is an overzealous lobbyist drafting language, because it's sort of a weird thing to put in a statute. Certainly from a federalism perspective, the federal government may have the power to preempt a local government from doing something. For Congress to pass an act that orders a local government to take an affirmative act is, I'll just say, a trifle unusual.
Well, let's just take it for what it is. Section 6409A is about 5 years out from good circuit court decisions and maybe even a Supreme Court decision because of the 10th Amendment. And while the drafting may have been peculiar, it is a command by the federal government for states and local governments to do something. So there are serious constitutional issues. And with great respect to my friend sitting to my left, frankly, the more the FCC does to embody that command, that federal command that we do something at the state and local level, it simply adds to the fuel to the fire. This is a law that I believe will end up being taught in law schools because as a practical matter, it doesn't get much clearer that this is clearly a obligation placed by the federal government, by those people who are remote from the people who have to enforce it. So understand that while we will be living under 6409 for a good deal of time to come, there will be the background questions and inevitably the lawsuits that will probe to find out just how close to the 10th Amendment this particular section gets. And frankly, I think it's gotten real darn close.
Yeah, the only thing I'd add is there's a flip side to that. Conversely, there are ways the FCC could construe 6409 to ameliorate that conflict as well.
Yep.
So it's all in your lap.
Be nice to us.
And we are, of course, aware of all those things, and they, they all go into the mix of the Commission's consideration. It is generally incumbent upon an agency to, to construe a statute where possible in a way that conforms with the Constitution. Of course, it is not clear exactly what the Constitution says in this case, and it is also our, our duty to be faithful to the statute. So we, those are all being considered by some of our lawyers who focus on those particular issues more closely than I do. But it's. Well, you'll see when the order comes out where it all lands, but it should be obvious in the order that those will at least have been things that we have thought about.
And there is related to that just one other issue, since I don't see a line to bring for the panel, and Jeff mentioned it very accurately, and it arises in the comments. And he mentioned it when he was talking about, a local government's proprietary capacity versus their regulator capacity. I mean, granted, I'm biased because I participate on the side of local governments. It seems clear to me the only way to rationally construe 6409, just like as 332C7 has been construed, is to apply to land use authority. That is to limit, in certain circumstances, the authority of a local government in its regulatory capacity of regulating private use of private land, but not to relate to access to municipally owned property, whether that's right-of-way, municipal utility poles, or whatever. In other words, no one would say, for instance, that if Congress passed a law ordering private landowners to allow facilities to be placed on their property, that would pass muster. Well, there's really no difference in the sense, and this runs us back to the DAS problem again as well. If the primary desirable location, and understandably so, are utility poles in the right-of-way, there's the separate issue of whether the statute says anything about access to facilities in the right-of-way that do not belong to the provider or to a utility pole that does not belong to the provider. But there was a back and forth in the comments on that issue.
Yes, there was.
Any other questions? Well, we have hit it right about on the nose. Thank you very much for your patience and your attention.